Gentlemen of the press, as you are no doubt already aware, my party, the People's Democratic Party, PDP, has instituted an action at the Federal High Court, Abuja Judicial Division in suit number FH/ABJ/CS/650/2021, PDP versus INEC and 5 others challenging the virus of the Zamfara State House of Assembly as presently constituted to commence impeachment or any other proceedings against the Deputy Governor of Zamfara State elected on the platform of the PDP. You will recall that the Federal High Court has granted an order directing the maintenance of the status quo ante bellum by the court on the 19th day of July 2021. The court order has served on the Chief Judge of Zamfara State House of Assembly, and the Governor of Zamfara State. Notwithstanding the service of the said court order, Mr. Emmanuel C. Okala San, and distinguished life bencher, wrote a letter to the Honorable Speaker of the Zamfara State House of Assembly, drawing the attention of the Speaker and the House of Assembly to the court order and the suit number FH/ABJ/CS/650/2021, PDP versus INEC and 5 others challenging the bias of the Zamfara State House of Assembly as presently constituted to commence impeachment or any other proceedings against the Deputy Governor of Zamfara State elected on the platform of the PDP. Despite the foregoing state of affairs, the Speaker of the Zamfara State House of Assembly and the House of Assembly have now embarked on steps and actions to overreach the pending suit, disobey the court order, render the effect of the suit negatory by scheduling a sitting to proceed with impeachment proceedings on Thursday, 29th July 2021, today, against I, the Deputy Governor of Zamfara State. I am of the honest view that action will be improper, indecorous, inappropriate, and unlawful, as it constitutes disobedience to court order and will be tantamount to a flagrant breach of law and enunciated in a host of Supreme Court cases, such as the Supreme Court cases of Waswani versus Sabala, 1972, Ojukwu versus Governor of Lagos State, 1983, and Mohammed versus Olawini, 1993. These cases have laid down the principle which has become time-honored and settled law beyond peradventure, where there is pending application pursuant to an appeal before a court. No action aimed at or capable of fostering the court a fait accompli by render its decision negatory should be taken or entertained. In fact, the parties should not engage itself in speculation by concluding or assuming that the application before the court will fail, because an action before a court is the civilized way of enforcement and maintenance of the legal rights, and a person that takes that course of action should not be silenced or forced to abandon or renounce his right to complain. I am constrained to draw the attention of the public this ugly situation in the matter, in the hope that well-meaning citizens and people of goodwill will call the House of Assembly of Zamfara State to order and impress upon the need to obey the subsisting order of the court and respect the judicial process, to exercise restraint and await the outcome. Thank you for your understanding.